So good evening, class. Jennifer Utter here, HR Law for winter 2016, and these are just some very brief comments about LP2 in our Human Resource Law class winter 2016. So last time we spoke about elements of a claim, and we used the acronym IRAC, which stands the I for issue, the R for rule, the A for analysis, and the C for conclusion. And any time as you are finding out, as you're studying and reading, as you're finding out, the elements of a claim must be met for a plaintiff or an employee that is aggrieved by some type of employer action to be successful. If those elements are not present, then the student, or excuse me, the employee does not have a claim. This is a very cut and dried rule. If the elements of a claim are there, then the plaintiff can proceed. If the elements of a claim are not even there, then the case will get dismissed on summary judgment before it ever even goes to trial. So where you're going to see the elements of a claim discussed are when any kind of court case or when any kind of legal writing is talking about the rules. These are the rules. These are the elements. You've got to be able to meet these their eligibility requirements. You'll also see the elements of a claim discussed in the analysis portion of any legal writing. And that's because you're trying to figure out whether or not the facts of the case fit the elements of a claim. And especially as you are moving forward in your HR career, maybe you're working in HR, if the elements of a claim are not met, then the employee does not have a claim. As we have found in this LP, discrimination and those protected classes against discrimination, it applies to all steps in the employment process. Chapter 3 contains that summary of the protected classes. These are applicable throughout. They're also applicable pre-employment in the application process, and we've seen a little bit of this in the discussions. It's not necessarily appropriate to ask, what is your birthday? Instead, ask in an application, are you at least 18 years of age? And that is a fair question, because when you're 18, you're able to contract, you're able to control and have liability for your own actions. Minors are not able to contract. If you're a minor, even if you're some kind of celebrity child, your parents or your guardian has to contract for you. You cannot contract on your own until you're at least 18. So that's a fair question. So even with this suggestion, as with many other end runs, this doesn't necessarily stop discrimination. Employers are going to figure out your approximate age anyway, possibly by your educational information, for instance. When you graduated from high school, people are usually 17, 18, 19 years old around that time. They'll be able to find out based upon how long you were at your previous employment. And so ages can be approximated. And so all of this can be in many ways figured out by employers in any event. I mean, frankly, if you had an in-person interview with me and you looked at me, you can tell I'm not 25. And so obviously, even just by our looks, people can tell approximately how old we are. However, what that does mean, no matter what, is whether you are an employee or potential employee over age 40 or not, then or maybe you're in a different protected class. And especially as employers, as you're interviewing, you need to make sure that there is enough justification in your denial of an employment application or offering the job to a certain person that doesn't have anything to do with any of those protected classes. And so especially if you're working with an employer, and as I would advise any employer that came to me and said, well, how can we not discriminate? And the answer is that you just need to protect yourself in your decision-making process so that no one thinks that there could even be the hint that you were discriminatory. And so what you've also been reading about and what your LP2 assignment talks about is the fire department case, the North Hudson case. And so even though an employer might have some pretty good reasons, if it has a disparate impact, or if it's just maybe not intentional, but by virtue of your requirements, it results in a discriminatory result, then that process and application process needs to be reevaluated. So as an employer, you just need to be protecting yourself and making sure that not only are you in compliance with the letter of the law, but also the effect of the law. And if you're going to, and this is good business anyway, have reasons for not hiring the person that you don't hire, and for the most part, you're going to be okay. Let's talk just a couple comments about employment eligibility and also drug testing. Two absolutely huge issues in the employment world, and maybe you even have some experience in your own industry. But quotes, illegal workers. So who is able to work in the United States? Citizens can work in the United States. Aliens that are here legally can work in the United States if they meet certain requirements of their type of visa. Bottom line, illegal aliens are not supposed to work in the United States. And yet, if you look at the statistics, there is a very large portion of the illegal alien population that is gainfully employed in the United States. And so to the extent that this people group, ineligible people group, are filling a need within our economy and within our culture in the United States, there is a real temptation for many people to just go ahead and hire them and hope that they don't get caught. And so there's some very huge consequences, not only for the employee, but for the employer as well, for hiring illegal aliens. And that's where we've now resulted with the I-9s and showing your birth certificate or showing your social security card or your driver's license as you are attempting to get work in the United States. Employers are going to need to document that the people they are employing are valid and eligible to work in the United States. And that's fair. I mean, here we are, we're in America, so let's follow the rules of America, okay? A couple comments about drug testing. Huge choice issues there. However, I think the biggest takeaway is just because marijuana might be legal in Colorado, it does not prohibit employers from requiring a drug-free workplace. And I've seen some of those discussions and that discussion about, wow, do we let people smoking pot continue on? If we know that they come, do we even continue with them? And so that's just the big takeaway from that. But yet there are still people that say, hey, I legally smoked pot in Colorado, so why can't I come to South Dakota and do my job at the hospital? I smoked 30 days ago, and marijuana stays in your system for 30 days. Well, the answer is, in South Dakota, as soon as you come across the border, possession of marijuana and that chemical component of THC, which is that active ingredient in marijuana, is illegal. It's illegal to have THC in your bodily fluids without a prescription. And there is no prescription available in South Dakota. Now, so now I would like to draw your attention to a very interesting issue that's happening in South Dakota. We have just this year, or maybe at the end of last year, a casino on one of our Native American reservations, which has a hotel which allows people to smoke pot. And so even in South Dakota, we have these sovereign nation resorts where people can go and they can drive there. You don't go through a checkpoint or anything. You're just driving along the road, and one minute you're in the state of South Dakota, and the next minute you're on the Yankton Sioux Reservation. I can't remember where the hotel is. It's on the eastern side of our state, which is about 5 hours away near Flandreau. And so yet here we go. Here are people that are driving there. They're smoking pot there, and it's okay to smoke pot there. But as soon as they drive off the reservation, they are committing a misdemeanor crime. They have marijuana in their bodily fluids. And so it's a measurable amount, and they can be arrested for DUI if they're driving while drug impaired. And yet, how do they get there? How do they get back to their house? What if they're going to another state where marijuana is not legal? So you can see a lot of information on the websites about which states have legalized marijuana. And this is an issue that is not going to go away, and especially HR employees and companies are going to really need to clarify and get some real direction with what they want their policies to be. And then if people don't want to follow their policies, then they don't have to work there. And at some point, you have a choice whether to smoke marijuana or not, right? So I'm smiling there. So issues like that secondhand smoke, it's all about choices. And it's about making the legal choices if you are an employee and you're on employer's time, and if you're an employer, making choices about policies in your workplace. Let's just follow the law. So the real challenge for businesses is to hire the right person for the right job according to their skills, abilities, and nature legally. And there's quite a bit that goes into the hiring process. Many companies have, for instance, pre-employment testing, psychological testing to see if they can handle the stress. For instance, emergency personnel type public servant jobs. I've seen that there, and those have been upheld. And there really is a certain right person for certain jobs. However, we have to do that legally without discriminating on any of those protected classes. So here is your LP2 Seminar assessment. In your assignment case, you've already read this case. Everybody's got this. This is found on chapter 4, page 113 of the textbook. All I am requesting is that you write the claim that the employees brought forth against North Hudson and the elements of that claim. So you're going to have a claim, and it's going to be some kind of a discriminatory claim, and then it's going to have certain elements. And I'll even fill in the first one for you. One of them is that you have to be an employee, or you have to be a potential employee. So there's certain activities that a person has to step forward and be falling under the elements of this claim. Just put them on a single sheet of paper. You put the heading at the top, LP2 Seminar Assessment dash student name. So it would say LP2 Seminar Assessment dash your name there. And I'm not requiring this to be an APA format. You don't have to put a title page. You don't need a reference page. You just need one line with the correct information, one page with the correct information. You write the claim, and then you write the elements of that claim that the NAACP was bringing against North Hudson Regional Fire and Rescue. This is all in the case. my goal for you, I would just like you to be able to recognize what the claim is and what the elements of that claim are. What does a potential employee or an employee have to prove to prevail and show that there was some type of discrimination? There are numerous examples in your textbook of this. The answer to this is right within this case that you have been looking at and hopefully writing about for this last time. And so it shouldn't take you very long. I would say 15, 18 minutes at the most. You go to the case, you find the claim, you find the elements of the claim. And there's also, I know, in the literature, some information. So if you want to go and look up this case and look at some law review articles that talk about this case, it'll give you the information about the claim and then the elements of that claim. And so start thinking like that HR professional that needs to protect their company. Are we acting in a discriminatory fashion with our current policies? What are some recommendations for change? If you have any questions, please don't hesitate to give me a call, 605-786-3974. Send me an email within the class anytime. Keep up the good work. And once again, I apologize for the delay in getting this out to you. However, since you are the seminar assessment is built right into your LP2 assignment, I really don't think this will take you very long. It's nothing tricky. Just trying to find out if you can spot what a claim is or what type of discrimination is being alleged and the elements of that claim that a plaintiff has to meet to prevail on that claim. If you have any questions, please give me a call. I think I've been able to answer some questions so far, and I look forward to meeting with you online and continuing in this class.